Sumit Chander, lawyer, and Brunalini Deshmukh. Sumit Chander, the biggest question in this case is, how did the mother-in-law get the bail to begin with? This case was filed under the provisions of Prevention of Dowry Act. How did she get bail even as, their 48 hours were taken to register the FIR, and she's been not only got a bail, she hasn't been questioned yet. The police has not bothered to record her statement. She says police did not bother. Police says she did not comply. What botch-up is going on here?
The bail, of course, is a discretion. But of course, in situations like this, normally bail is not allowed. I'm sure she must have produced some grounds where the court took consideration. But that is again something to be seen, what was put. And that is why possibly now the matter is now shifting from police to CBI. What is the report of the police? Because police would have filed its report to say whether she was needed in the investigation or not. So those factors also come into consideration while deciding a bail. But anyway, in this case in particular, I would say we should divide this into three layers if you want to analyze this case in particular. In layer one, first, and none of these three layers should be mixed up. Keep that in mind. In layer one, you need to see what is the cause of the death. Are we taking the line for the abetment of suicide, or are we taking the line that it's a homicide staged as suicide? Second, in layer two, whether can be considered as a matrimonial cruelty, and if there is a matrimonial cruelty, is there a dowry angle to it? For that, you need to see whether there existed a sustained harassment and coercive conduct, and of course, whether there have been demand for dowry soon before this death. Third layer, you will have to then, which is the question here, is the investigation integrity, whether the collection and preservation of evidence was lawful and complete. Now that is where today everything is moving around and everything is trying to be bypassed in law. So it is the attempt, but at the same time, I think now the High Court has intervened in an appropriate manner and now taking action by shifting the investigation from police to the CBI.
Chand, the lawyer, is also still with us. We also hear someone there, I think another lawyer, saying that, he's trying to run away from here. He has a lookout circular against him. Where is the SIT? Why don't they nab him? Clearly, not the kind of scenes that you would like to see play out in court corridors themselves.
It is very, very unfortunate that today, I mean, the kind of harassment, he is an accused today. Let us be very clear. He is not a convict. There is a trial that is to happen. It may be very apparent, may not be apparent, but still everybody has a right of investigation, a proper and fair trial. I feel he is being punished already before the trial.
But they're also trying to act a little bit too clever by half, no? Landing up in Jabalpur, absconding for 10 days, his family is going out and trying to character assassinate the deceased woman, and he's absconding. Now he wants to surrender, but on his own terms. This is not happening in a vacuum, Sumit.
Not only this, in fact, the most apparent thing was that the person is in a position, of course, because of his mother,
of influence,
in a position of influence.
Yes.
And not only that, there are evidence to show that influence was attempted to be used. Now, when such things are so apparent, and then of course the legal jargons, I'm going beyond the legal jargons, there are other aspects. All I'm saying is these things, unfortunately, today are not being done just purely legal and quietly. It is now in the public domain, the way things are happening. But again, I don't blame media for this. It was the accused who initiated bringing the media on board and trying to give an explanation outside the legal system. So now that you've created it, made a balloon outside, you will have to face the consequences. But still, I feel, some level of responsibility, at least to lawyers who have been shouting. I think it's not fair. If investigation is to take place, if SIT has been constituted, if he is to be arrested, I'm sure if they are aware, being there in the court, everybody is aware. The whole country is watching today. But making such statements randomly out of the blue will not be fair. I think he should be just allowed to enter the court, argue his case, get the decision, and that's it. I mean, rather than just stopping him at the corridors and stopping basically or hindering the process of law itself. So let law take its place, give him some space, I feel. And this is a courtroom where we are talking about. This is not some park. So I think that restriction somehow should be avoided and this accused should be allowed to visit the courtroom and explain his case to the judge.
Yeah, I mean, nobody's suggesting that they shouldn't be allowed the legal recourses that are available to them. But the only point right now is that has this family already been successful in kind of deviating from the what would have been a natural course of this probe? On top of that, has there been an abuse in the spirit of the law as far as how things have panned out so far, Sumit?
See, I am with you partially on this, though I'm always in favor of the procedure. It is my faith. Things go in a certain direction. But in this case, I think media's intervention at the right time has definitely helped the case. I'm not saying whether things will come out differently on a second postmortem, but the second postmortem happening, the involvement of CBI, these are very important signals that have come in that at least the government as well, the authorities as well as the High Court is attempting, or not only attempting, but making it that law and justice should not just be done, it should be seen to be done. Now, let us
To be done.
understand why. That
Yes.
just 2 points I'll come in. Let us understand why the courts permit a second postmortem. It's very rare. It's not something which happens in a regular routine.
Yes.
A second postmortem is usually permitted by the courts on two aspects. One, if the first examination appears to be incomplete.
Yes.
And second, whether material facts require clarification. So I'm sure at least the court at this stage has felt that material facts require some clarification. So, and maybe the first examination appears to be incomplete. So those aspects have come. But just because a second postmortem has been done, it is not a declaration that the first one was wrong. Again,
Sure.
it's a judicial safeguard to discover the truth, and the truth would come out after the second investigation.
Yeah.